Hi everyone. In last week's video we focused on a particular misconduct case and really examined the range of reasonable responses test which an employment tribunal applies in cases of unfair dismissal involving misconduct. There is a link into this week's subject in that we're going to look at conduct outside of work and where that impacts on the employment relationship. And again, the test of the range of reasonable responses will come into play when considering the fairness of the dismissal. So it's clear from case law that conduct, as a fair reason for dismissal under the Employment Rights Act, does extend to conduct outside of work as well as in work, the key issue being whether that conduct pertains to the employment relationship. So, in essence, trying to link the behaviour to a particular impact or effect in the workplace, which makes it impossible for that employment relationship to continue. This was explored in Sing and London Country Bus Services. So that it may be fair to dismiss an employee for misconduct outside of the workplace, so long as in some respect or other it affects the employee or could be thought to affect the employee when he's doing his work. First case example we've got of this is Eggleton and Kerry Foods. So in this case, Mr. Eggleton had a bit of a long-running feud with a colleague over a former girlfriend. He instigated a fight in the car park and I believe came out on top. He admitted to his misconduct. I think it was caught on CCTV, and the other colleague no longer felt safe to attend work. By all intents and purposes, he was defending himself and wasn't involved in instigating or provoking the attack. So the Employment Appeals Tribunal said yes, this was a purely domestic matter. The fight didn't take place on the premises. It was across the road. It wasn't during working hours. But the Appeals Tribunal agreed with the employer that trust had been broken. He couldn't work with his colleague anymore, and these violent outbursts were clearly a threat to other colleagues. We will, in a future video, focus on specific social media cases, but just to say, social media, of course, is something which arises often outside of the workplace if it's not on a professional networking site. Cases involving violence, sexual conduct or dishonesty away from the workplace, those are the types of cases that are most likely to affect the employment relationship. That might be because of the particular nature of the work. So, for example, somebody convicted of a financial dishonesty offence who works in your accounts team, or because of general considerations about damage to the employer's reputation. And the reputational point is one we see most really, where employers are wanting to dismiss as a bit of a knee-jerk reaction by saying there's damage to the reputation in light of an employee doing X, Y, and Z. Difficulty being, they have to substantiate that, or there has to be a genuine risk which can be substantiated of that reputation being damaged. So one of the cases involving that is Keeble in London Borough of Hammersmith. A council employee dismissed for his conduct at a political rally, which he attended in his own time in a personal capacity. He was filmed having an exchange with a demonstrator expressing controversial views, and this led to him being identified in the media as an employee of the London Borough of Hammersmith and Fulham. He was dismissed for misconduct on the basis that the comments were inappropriate, likely to be considered offensive, and would bring the local authority into disrepute. Now, that was a case where he was found to be unfairly dismissed. So I expect that the assessment of that was that the employee was free to express his own views to an extent. Perhaps the gravity of those comments in terms of inappropriateness was judged too subjectively by the employer, and in essence, in effect, there was not enough reputational damage to justify dismissal. Next case is Isherwood and West Midlands Trains. Mr. Isherwood, long-serving employee with an unblemished record, senior manager in a business. Now, this was only 2 years ago. He attended a mandatory training session on white privilege and unconscious bias. This was on a Teams call while working from home, so this is quite topical because it will be becoming more and more prevalent, I would guess. Now, after the call, he didn't realise that he was still connected to the Teams event, so everybody could hear what he was saying, and he made comments to his wife which were offensive and which essentially were in complete contravention of the session that he'd just attended. His view was, well, that was a mistake, but it was part of a private conversation with my wife. I didn't intend anybody to hear that. But he was dismissed for gross misconduct. The employer saying that colleagues could have taken offence, and the comments breached the equality, diversity and inclusion policy, and the employer had been brought into disrepute. Now, on the disrepute point, there was no suggestion that the remarks had been disseminated outside of the small group that were attending the training. So we come to proportionality, we come to that range of reasonable responses test, and the tribunal said that a reasonable employer would have given the employee opportunity to comment on the appropriateness of a warning. They should have considered matters such as providing further training or asking the employee to make a wider apology. The comments were never intended to be heard by anyone else and were not actually discriminatory, racist or generally unlawful in any way. So it appears that the employer has engaged in a disproportionate response, has assumed that there would be reputational damage, has assumed that there would be offence caused and that the employee would show no remorse. Look at the conduct, look at the impact on the employment relationship, look at alternatives to dismissal, and identify whether or not, in all of the circumstances, dismissal really would be within the range of reasonable responses. So in a future video, we're going to look specifically at social media cases outside of the workplace. But for now, if you do need any further advice on anything you've heard today, please do get in touch by emailing employmenthub@chadlaw.co.uk or visit the website chadwicklawrence.co.uk. Thank you.